You may have heard somebody tell you, you should get a will for when you die. But is that all you need? Is a will sufficient? In this video, I'm going to go over the different parts of an estate plan and what you need for planning ahead when you're gone or if you're sick. Now, you may hear the term estate plan and you think, ooh, it's a big fancy mansion. It sounds like estate. But this is really something that just about everybody needs. And so I'm glad you're listening. Okay, so when we're looking at an estate plan in California, there's 4 cornerstone documents that everybody needs. And the first document is what we call a revocable living trust. So this is actually a contract or an agreement between you setting up the trust. You're the creator or the settler or the grantor, and you as the trustee, you're the manager of the trust for the benefit of you as the beneficiary. You wear all of the hats of the revocable trust. And so it's what we call a see-through trust. You don't have to get a separate tax ID number. You don't have to file separate tax returns. It's all under your 1040, but you can change it whenever you want. It's your money, and the best thing is it avoids probate at the time of your death. And probate is a horrible, expensive, time-consuming process that all of my clients should want to avoid. So you set up your revocable trust, and this really is the cornerstone document. In the revocable trust, you say, where do you want your money to go upon your death? What if your kids aren't alive? Where should things go if you have kids? Who should manage things, okay? And then you fund the trust, which we'll talk about in just a second, okay? So the revocable living trust really is the main document in planning. So you might say, well, Ellen, what about this will thing? I've heard that I need a will, right? Well, it used to be that people would use wills, and in their will, they would say, you know, I want this to go to this person or this to go to this person. I think about movies like Gran Torino or Knives Out, where they have these big will readings and people sit down and they go, I hereby bequest my Gran Torino to my neighbor so-and-so, right? It doesn't work like that anymore. What happened was the will had to go through the court system. Even though it said where things go, you still needed a judge to supervise everything. And people were like, especially in California, well, that's ridiculous. There are some states that have really nice probate court systems where things fly through nicely when somebody only has a will. And that's fine, but California is not one of those states. So you definitely want a revocable trust. And then we prepare something at the same time called a pour-over will. So the pour-over will basically scoops up any assets that you forgot to put in the trust and it pours it over into the trust. So it's really a cleanup document. The pour-over will, when you read it, it should actually be pretty boring. It basically says, I want everything to go into the trust. But it's also in the pour-over will that you can nominate guardians for your minor children. If, God forbid, you should die and a guardian needs to be appointed. And that always goes through the court process. So that's why it can be put in the will. Okay, so those are documents 1 and 2, the 2 most important ones. And the third document is called a durable power of attorney. And we set this up for financial management. So if you're alive, but you're sick and there's an asset outside of your trust, your agent under your power of attorney can manage that asset. Now, it's kind of funny that the agent is actually called an attorney in fact, which is a horrible name for this because they're not an attorney. And in fact, they're not an attorney. It's just maybe a family member or a friend who you're naming who you can say, hey, this person can manage things if I'm sick or even if I'm traveling. Okay, so it gives somebody else access. And in that way, you can avoid a conservatorship. I've had cases like where a 40-year-old man had a heart attack and he didn't have a power of attorney set up. And we had to go to court to get the judge to allow the parents to sign on the son's behalf. It was horrible. So the durable power of attorney for finances helps you avoid that conservatorship process. The fourth document that you need is called an advance healthcare directive. And this used to be called a durable power of attorney for healthcare. They changed the name, but you might see either one. This is basically the document if you're in the hospital and you're really sick. Maybe you're unconscious, you can't speak for yourself, maybe you're in a coma, and you can't communicate what you want done, what your healthcare wishes are. So you have spelled out your own healthcare wishes in this document. And then you name somebody, a trusted family member or friend, to carry out your wishes. So that person can go and bring this document to the doctor and say, hey, look, this is what my mom wanted. This is what, and basically advocate for you on your behalf. Because if you've known doctors, some are very humble, but many are not. And they need an extra push to make sure that your wishes are carried out. So that's the 4 most important documents in my mind, okay? Then there's also some documents that help you to fund your trust. So as I mentioned, a trust is like a basket and things need to go in there. So typically, if you have a residence or other property in California, we would prepare a deed to transfer that property into the trust, and you'd sign it before a notary and it's recorded with the recorder's office. So we would typically prepare that. Another document we prepare is called a certification of trust. And this is a shortened version of your trust document. This can go to your financial advisor and it gives them all the information that they need to title your savings and brokerage accounts into the trust. Another document that's very helpful is something called a general assignment. So this is where you say, I want all my stuff to go into the trust. So I want to give a little bit of background to this document. So the big issue is if you die and you don't have an asset in your trust, how do we get it into your trust to avoid probate? All right, what we used to have to do is at the back of the revocable trust, you'd have to write up a list called a Schedule A, which says, these are the different assets that are in my trust, okay? And you'd have to update it every so often as you acquire new assets or you sell other ones. You'd have to keep your Schedule A updated. And what the Schedule A basically says is, if I forgot to title something, this is my indication that I wanted it in the trust, right? It's listed here at the back of the trust. Well, there's been some recent court cases, especially Estate of Hegstead, and another one that's similar sounding, Estate of Ukested. Go figure, right? And those cases say you don't need to prepare that Schedule A anymore. Instead, you can have something called a general assignment that says, I want everything to go into the trust. So that's enough evidence to the court that you can put that asset into the trust. So you bring something called a Hegstead petition. You say, Judge, I'm sorry, we never quite got that $1 million brokerage account into the trust, but can you please rubber stamp it into the trust? So that's why we prepare the general assignment, and typically we don't do the Schedule A. Now, this is really county specific. So if you live in a county like Alameda County or San Francisco County, you still need to do a Schedule A because courts there don't like general assignments, even though they should accept them. But most other counties will accept a general assignment. So just depends on which county you reside in. Okay, so also part of your estate plan, you can prepare a list of different items that you want to go to different people. We call that tangible personal property. This is your stuff. Typically your stuff in your house or your cars or your jewelry. You can name the item and then say where you want it to go. And we call this a tangible personal property memo. Very creative, right? And so you sign and date it, and we put a reference in the trust that you want the trustee to carry out those wishes. Okay, this is something that you can update at any time. You don't need us involved because these changes happen quite frequently. Now, the trustee is not required to carry out your wishes, but they just about always do. So that's another thing that we would provide as a blank tangible personal property memo that you can fill in. Okay, then there might be some other interesting assets you might have, like say you have an LLC interest or a partnership interest. A lot of times we'll prepare an assignment, a specific assignment for that interest to say, I want that to go in the trust. So it has a mechanism upon your death to make it into the trust so it can be distributed according to the terms of the trust. So now you have a better idea of what an estate plan should contain. If you'd like to learn more about general estate planning, I've prepared a webinar that you can click right here and it'll take you to this webinar. So I'll see you there.